whatsoever. That disqualification petition is received by me on the 25th, admittedly, and I'm talking about the short period of facts within which this took place. It's sent to me on the 25th with a direction to reply on the 27th. Now, my Lord, your Lordship may just note one more thing, that under the 8th paragraph of the 10th schedule, rules are to be framed. Rules have to be framed. They are called the disqualification rules. Rule 7 prescribes that from the receipt of a petition by the noticee, by the person who is to be disqualified, he has a right to reply within 7 days. This is Rule 7.3a. My Lord, it's 7.3b. 7.3b. I'll just read it quickly. If the petition complies with the requirements of Rule 6, that is the disqualification petition, the Speaker shall cause copies of the petition and of annexures thereto to be forwarded to the member in relation to whom the petition has been made, and where such member belongs to any legislature party, and such petition has not been made by the leader thereof, also to such leader, and such member or leader shall within 7 days of the receipt of such copies, or within such further period as the Speaker may for sufficient cause allow, forward his comments in writing thereon to the Speaker. I have a right, as per the rules framed by them, the Maharashtra Legislative Assembly, under paragraph 8, to reply within 7 days.
So the notice was not in accordance with Rule 7.3b according to...
That's the trigger, one of the triggers.
So then what is the next point then?
Next point is we move the Supreme, this Honorable Court.
Excellent.
And the bench, one of the grounds taken there, but it's contrary to Rule 7. Please give us extended time.
27th, you moved the Supreme Court.
We moved the Supreme Court on 27th. On 26th, matter came up on 27th. Now, Your Lordship will just see that order. Because they seem to be aggrieved by that. The second aspect of this case which they are aggrieved by is that so-called quia timet order of 27, which is not a quia timet order. It is only, there are only two aspects of that order. Order dated 27.
Our court postponed the date for submission of the reply to 12th of July.
12th? And no, there's a very significant aspect also. I was in Guwahati at that time. Now, not that it has a great bearing on this case, but I was given the protection order. Please see the last paragraph of that order. I complained that I'm in Guwahati. Mr. Shinde, the now CCM, his son's office was burnt. And my Lord, I was receiving, the 34 MLAs were receiving threats. My Lord, very serious threats, which is part of an affidavit we circulated yesterday. And my Lord, we asked for protection. We were told that if we come to Bombay, our dead bodies will be sent to a moratorium. So, my Lord, this is what the court did. That's the only relevant part. Mr. Chitnis, in view of these allegations, Mr. Chitnis, Learned Counsel for the State of Maharashtra, states that adequate steps have already been taken and the state government shall further ensure that no harm is caused to the lives, liberties and properties of, my Lord, by that time it had swelled to 39 MLAs, of the 39 MLAs and their families. So, my Lord, those are the two aspects of the case. Now, how does that prejudice them? The state of Maharashtra voluntarily makes a statement. There is an explosive situation going on in the state of Maharashtra. These legislators and their family members were threatened.
The issue of whether or not to refer Nabam, what is the sequitur so that you can formulate the point and tell us?
Yes. Now, my Lord, the thought to refer is that all these aspects which they claim to be aggrieved by. Well, as I said, there are three aspects. One is the notice. The second is the quia timet injunction, which is not a quia timet injunction at all. No prejudice was caused to them. And no, this order was passed on the 27th. Please note, my Lord, that on the 28th, the governor orders a floor test. What prejudice has been caused to the speaker in the discharge, which, my Lord, of his power of disqualification? Where is the prejudice which my learned friends, my Lord, have my Lord, so profusely argued about? 28th, this floor test is called. Now, my Lord, the floor test, Your Lordship, I only cite one judgment. My Lord, the judgment in Shivraj Chauhan's case. So, my Lord, I'll just, the relevant paragraphs only. My Lord, this is at 1376 PDF, page 1376.
Volume 1.
Compilation.
Volume 1. Judgment compilation. 1389.
1-3, sir.
Volume 1.
PDF 1389. PDF 1389.
What is it? What is it?
Bookmark number.
Book number.
K. Jera? No.
60, P62.
No, I'm sorry. That has 36 bookmarks. If we are talking of the judgment compilation.
33.
Can you give us the citation?
Sorry?
Read by compilation, Shivraj Singh
Bookmark number
Chauhan.
33. Sorry.
Right.
Sorry.
Got it.
Bookmark number 33.
That's okay. Got it. PDF 1339. Shivraj
That's it.
Shivraj Singh Chauhan.
Shivraj.
1326.
It is 137.
But
Starts at
your lordship may come directly to PDF 1389,
8.
paragraph 79. Now, this is titled Short Circuiting the Speaker's Discretion. This is what they seem to be aggrieved by. I'll just read this now.
Just a moment, please.
A significant ground of attack by Dr. Singhvi, learned senior counsel appearing on behalf of the Speaker on the decision by the Governor to call for the trust vote.
Just one.
Yes, sorry.
We've yet to get it. Some
I'm sorry.
You got it.
I have
1389 is the PDF.
Yes.
para 79. Just please 1 minute. Sorry, I'm detaining everybody. Which is the PDF page, Chief? Just. Yes, please.
A significant ground of attack by Dr. Singhvi, learned senior counsel appearing on behalf of the Speaker on the decision by the Governor to call for the trust vote is that convening a trust vote at this stage will impinge on the discretion of the Speaker to determine whether the resignation should be accepted under the provisos of Section 193B, and at the second level to decide upon the consequence of the resignation in terms of the anti-defection provision of the 10th schedule. Short-circuiting is the phrase which was used by Dr. Singhvi. Implicit in the submission is the charge that holding a trust vote impinges upon the discretion of the Speaker on whether to accept the resignations and to decide whether these members have incurred the wrath of disqualification. While analyzing the submission articulated by Dr. Singhvi, the cobwebs need to be cleared. The Governor does not decide whether the resignations that were submitted by the members were genuine and voluntary. That is squarely a matter which lies within the domain of the Speaker. Similarly, but not emphasize, whether a member of a House has discarded a disqualification under the 10th schedule is a matter where the Speaker is the designated authority. Conscious as this court has been on the fact that these matters, which lie within the domain of the Speaker in the recent past, a direction to members to appear before Speaker and the Speaker to take decision immediately was recalled by a three-judge bench. Dr. Singhvi alluded to these orders. Now, Lord, it is very important. It is strike law that neither the Governor nor, for that matter, this court has the power to impinge upon the authority of the Speaker to take a decision on the above issues. The issue, however, is whether the convening of a trust vote has to be deferred until such time as the Speaker has taken a decision on whether or not to accept the resignations. And if so, the consequence of the members departing from the fold of the party on whose ticket they were elected under the 10th schedule. The holding of a trust vote operates in a distinct field from the issue as to whether one or more individual members of the Legislative Assembly have embarked upon a voluntary act of resignation or have incurred the wrath of the 10th schedule. But the same thing here, the disqualification petition is under 21A of the 10th schedule, which says I have voluntarily given up my membership of the Shiv Sena. Holding a trust vote is necessary to ascertain whether the Council of Ministers headed by the confidence of the House. Continuous existence of that confidence is crucial to the legitimacy and hence survival of the government. It is a matter which can brook no delay, since the authority of the government presided over by the Chief Minister depends on the Council of Ministers continuing to have faith of the legislative body as a collective entity, particularly when the members resign in an expression of lack of faith in the existing government. The convening, exactly what happened here. The fact situation is exactly what happened here. The convening of a floor test is the surest method of assessing the impact of the resignations on the collective will of the House. The consequence of the acceptance of a resignation is to reduce the numerical strength of the House. Until the resignations are accepted, the members who have resigned continue to be reflected in the strength of the House, having regard to the language which has been employed in Article 193B. Whether in the situation such as the present, elected government is entitled to continue despite the resignations of 22 of its members has a significant bearing on the issue of confidence. Neither the governor nor, for that matter, the court can infringe upon the power of the speaker. Now, the next sentence, next clause is important of that sentence. But the pendency of the proceedings before the speaker cannot be a valid basis to not have the confidence of the House and the government determined by a flaw test. Number 27, the disqualification petition was dealt with by this court, the two judge bench of this court. They extended time. The next day, a flaw test was called for the 30th. So, my lord, what prejudice is caused? Particularly the light of this judgment. My lord, then paragraph 81. We have highlighted the above factual scenario only to emphasize that the convening of a trust vote is of crucial importance to affirm the fundamental values of the Constitution, namely abiding by the rules which govern a parliamentary democracy. The fundamental precept of parliamentary democracy is that the government owes collective responsibility to the Legislative Assembly, and as a collective body, the Legislative Assembly is entitled to hold the government to account. The ultimate expression of accountability is the existence of or the lack of confidence in the Council of Ministers. We are therefore unable to accept the submission of Dr. Singhvi that the holding of a trust vote would short-circuit the jurisdiction of the Speaker on a matter of resignation and disqualification. Well, how is this different from the facts of the present case? On 28th, the trust vote was called for. It was held on the 30th. 29th, they challenged it. It was repelled. Rightly so, because this court has repeatedly held that you can't injunct the governor from calling for a flaw test or the holding of a flaw test. So, Lord, what prejudice is caused to them? Till you're actually disqualified, you continue to have the right to vote and perform all functions of a member of a legislative assembly. So, Lord, this one paragraph completely cuts the grass. So, Lord, this is another aspect, the quia timet injunction, and so these are the three aspects. The notice under 179C, which I said was stillborn because they said we don't accept this notice. Didn't have any further consequence. The quia timet injunction was necessitated by a breach of the rules on their part, giving me only 2 days when the Maharashtra Assembly rules, framed as I said under paragraph 8 of the 10th schedule, gives me 7 days. I had to go to court, inter alia for that. Nothing, there was no quia timet injunction, there was no restriction on him. All they were told, this deputy speaker was told, please comply with your own rules, give them the time, that's all. And I was given a protective order because of threats to the life of me and my family members and my other 33 MLAs, at that time 39 MLAs at that time. So, my lord, nothing in this case has at all caused any prejudice, my lord, to the plenary powers of jurisdiction. There is no case for referral in my respectful submission. And my lord, just one more thing. Ultimately, one more factual aspect. On 29th, the Chief Minister voluntarily resigned. His voluntary resignation was not the outcome of all that went before. He took a conscious decision. He knew he had lost the majority. He knew he had lost his majority and he lost. Therefore, he resigned instead of facing a flaw test. So the flaw test ordered on the 28th and to be held on the 30th was itself stillborn because the Chief Minister resigned on the 29th night, before the date even of the so-called flaw test. So, my lord, in this factual conspectus, there is absolutely no reason, my lord, because nothing has caused prejudice. My lord, this is, with the greatest respect to my learned friends on the other side, a case built on foundations of clay. There is nothing.
All right. Thank you. Anything else, Mr. Jethwani now?
No, just one last thing on Nabam area. Since your lordship has, a little, I'll only deal on that part and then I'm done.
You've dealt with Nabam Rabi. Your contention is that because the CM resigned and there was the 27th order of our court does not amount to any injunction on the exercise of powers by the Speaker.
Yes.
Therefore, there was no question of Nabam Rabi being invoked here.
Well, your lordship only want to know something about the notice period and the That part, 181. If you are not, the Lordship don't need an argument on that. You know,
No,
because-
we are not concerned with that so far as the reference to Nabam Rajya is.
Yes, that's. I'm deeply obliged. You know, that's all I had to say there.
Mr. Maninder Singh?
Well, as a tail ender, a couple of points, only few minutes. Well, there is no need for reference, my lord, is writ large in the existing constitutional scheme, my lord, prior to the 52nd Amendment in 1985 and even thereafter. My lord, your lordship had asked a question yesterday that besides the incorporation of the 10th schedule in the constitution in 102 and 191, 1022 and 191-2, these are the only, why? Because if the 10th schedule has to become a part of the constitution, some provision must incorporate it. Now, my lord, the question asked was why there is no further amendment in the constitution either with regard to 179, 180 or 181. The answer, my lord, is given by your lordship in Nabam itself, and I will just make a humble submission because Justice Narasimha was, my lord, having a doubt about the commencement of the action and conclusion of the action so that the bar applies. Now, my lord, kindly see 179 only for a moment. I have only to read 179 and 3 paragraphs. Your lordship may mark it, my lord. Your lordships have read it, but after reading this, the way I want to read it for your lordship's kind consideration, please mark, my lord, 235, para 235, 236 and 237 of Justice Mishra's judgment, my lord. But before that, my lord, I want to show your lordship article 179. And in my humble submission, my lord, the commencement of the bar under 179 of conflict of interest of the speaker, your lordships is provided in this article itself. Kindly see the nature of function. The highest of the function assigned to the speaker under the conventions, there is no provision in the constitution which says that the speaker shall preside. Because, my lord, the disqualification is you will not preside. There is no provision that he shall preside. I will take it, my lord, that is the whole purpose of having the speaker under the Westminster model, my lord, and therefore he has the authority to preside. That is his highest authority under the constitution to preside. If you are to take it away on the account of conflict of interest, it is that right to preside which is to be taken away. Because the requirement of conflict of interest is to keep him away when anything of his interest is being considered. But why right to speak? Because action is initiated against him.
It's a matter of natural justice.
Exactly.
Or he is going to be removed.
Now,
He is going to be removed.
now kindly see
You have to hear the speaker.
Now, under clause 6 of the 10th schedule, he is an adjudicator with finality attached to his decision. That's number one, nature of function. Number two, the nature of consequence. Removal of an elected representative. Kindly see these two. What is the nature of function to be performed? What are the consequences attached? The entire democracy is dependent upon election. Most valuable process is the holding of the election. Most valuable right is the getting elected and continuing the office for 5 years. Any cutting shot, my lord, any cutting shot cannot be a person with finality attached to his decision when there is a lurking doubt about his impartiality. When that doubt comes into existence, please see the proviso for 179. I'll read the main provision later. Kindly see the proviso. The proviso, my lord, in my respectful submission, gives the commencement of that date. Because 179C is a process. A process must have a commencement date and a process must come to an end. There are two dates which are important. In my respectful submission, the commencement date is in the proviso and the conclusion is 179C itself. During this process, when because of conflict of interest his highest right of presiding is taken away, he cannot be a judge with a finality attached to his decision. Kindly see 179, blood with me. Now please see 178, kindly see, very interesting. There is no word election or nomination in 178 for speaker. It is the word is choose. See the flexibility in the constitution. Now, generally we are exposed to the concept of election or nomination. In 178 for speaker or deputy speaker, it is choose. Now come to 179. Title: Vacation and resignation of removal from the office of the speaker or deputy speaker. I pause here for a moment, my lord. Can I say it is virtually a discontinuation and disqualification of that person to act in that capacity? It is, I can describe it loosely, my lord, with your lordship consideration. It is a provision dealing with the disqualification of discharging duty in that office. If he resigns, if he remains no more elected, and 179C. Finally, see, my lord, first the proviso. Provided that no resolution for the purpose of clause C shall be moved unless at least 14 days notice has been given. The notice word is used. Intention is included. Notice itself is an intention.
No, it is intent, notice is to intention
To move the resolution, my lord.
to move the resolution.
So, my lord, when Justice Bishop, I'm sorry.
That is why the problem is.
My lord, I'm saying that the emphasis is on the commencement date. When does that bar, 179C, read with 181 is a bar?
See, Mr. Counsel, proviso to 179 is only with respect to giving 14 days time from the date of notice of intention to move.
So, my
The
lord,
actual resolution would be only after 14
I
days,
see.
and the 29 persons signs that and
my
approves
lord,
that.
I'm coming to that. My lord, I'm deeply obliged.
Oh, it is not that much easy as you are suggesting, and
I'm not, my lord, I'm not suggesting, I'm saying something else. What is his right which is taken away? He will not preside. Because that is the highest of his right under the constitution. It is to be taken away. Now, my lord, this 14 days is also a notice to him to prepare for speaking. Which your lordship observed, my lord, that's a principle of compliance of natural justice for him. But when does that clock start that he will not perform an activity of a speaker because of conflict of interest? It starts, my lord, with the start of that process. And the start of the process is the intention and notice. And conclusion is, my lord, when the resolution is passed. In this entire interregnum, if you have to now apply to clause 6 of the defection law 10 schedule, the elected member goes out. The constituency has to visit for a second election again. And finality of the decision of the speaker. Speaker has no other adjudicatory right.
Maninder Singh, according to you, the
first
bar on the speaker entertaining a petition for disqualification must attach once a notice is issued of an intention to move a resolution to remove the speaker.
I'm deeply obliged.
For two reasons. First, that the speaker acts as an adjudicator under the 10th schedule. Second, there is a finality which attaches to his adjudication. And third, the consequences of an adjudication is that a member of the legislature loses their seat. So these are all three very serious consequences.
4, my lord, 4. The new, one more election is, my lord, put on the constituency.
Sorry?
One more election to be held for the you inflict another election on
So
the
the seat becomes vacant. The seat becomes vacant.
And my lord, therefore, it is not that is not conducive to any.
All right, we got now, Mr.
One more thing.
Now, let's move on to the other.
My lord, not take more time. I'll not repeat
Yes,
anything.
what's the point now?
Yes, my lord. Now the next point is kindly, and this is what is decided, my lord, keeping this in mind. Kindly come to 230.
We got your point that the conflict of interest in your submission, which should prevent the speaker from adjudicating upon a petition for disqualifying a member of parliament or the state legislature, begins the moment a notice is given to him of an intention.
And my lord, the pedestal, the participation as a speaker where he only, the highest of the right is presiding, Here adjudicator with finality.
That's
But
the
I'm not
reason.
reading clause 6. Kindly make a note of clause 6 of the anti-defection 10 schedule. Which, Malad, I'll just read.
You're arguing therefore that Nabam was correctly decided.
Now kindly just follow.
So Jethmalani's argument was that there is no reason for referring
Now,
now
my lord,
the facts of this case.
Now, my lord, the commencement of the process and conclusion of process is there in 179. I'm not saying anything more. Kindly come to state away para 235 of Nabam only for one moment.
Para 235.
235. After PDF page, my lord,
1167.
1167. Judgment volume, compilation volume 1.
Yes.
Kindly see 235 with me, my lord, where after taking note of article 179, 181, because everything is present to the mind of the Constitution bench. Now just permit me to read these two paragraphs and I am done, my lord. The purpose of referring to the said article, that is 181.2, that is, my lord, the bar. 181.2 incorporates a bar. Even in a normal conflict of interest, not as an adjudicator where the impartiality has to be of the highest order, is to highlight the nature of participation of the speaker when the question of his removal arises. It is clearly different. Under the Constitution, he is entitled to take part in the proceeding and speak. Therefore, he is in a position to contest. That is his right. Appreciating the scheme of the Constitution, I am placing reliance on this, not why there should not be any reference. Appreciating the scheme of the Constitution and especially keeping in view the language employed in the first proviso to Article 177 9C, it is quite clear that it is the constitutional design that the speaker should not do any act in furtherance of the interest till the in furtherance of his interest till the resolution is moved. 4 more, kindly see 236. 236 first 4 lines and then 237 straight away. In this regard, it is essential to understand the character of the 10th schedule. The 10th schedule to the Constitution has conferred adjudicatory powers on the speaker. Now kindly come to 237. The aforesaid reasoning eloquently speaks of the power, position and status office of the speaker enjoys under the Constitution. It also states about the scope of the fiction. The court has constricted the power of judicial review and restricted it to the state, carving out certain extreme exceptions. It is because the speaker, while exercising the authority, jurisdiction, exercise the power of constitutional adjudication. This one is reference to clause 6 under the 10th schedule. The concept of constitutional adjudication has constitutional value in a parliamentary democracy, and the constitutional values sustain the democracy in a sovereign republic. The speaker is expected to maintain propriety as an adjudicator. The speaker, when functions as a tribunal, has the jurisdiction authority to pass adverse order. Then, Lord, I pause here for a moment. He can achieve that objective within a day or two. Today, he gives a notice of disqualification, gives 5 hours of time, hold the proceeding and disqualifies. The speaker is expected to maintain propriety as an adjudicator. The speaker, when it is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible. It should be beyond any reproach. It must reflect the trust reposed in him under the Constitution. Therefore, the power which flows from the introduction of the 10th schedule by constitutional amendment is required to be harmoniously construed with 179C, my lord, which is in my respectful submission is a bar against participation in the nature of the duties of adjudicator, constitutional adjudication, and, my lord, finality. And then, my lord, your lordship only read one line in paragraph 238, which is, my lord, at page 1156, which is placidum A on the top and last 5 lines. It would be an anathema. Your lordship have got it, my lord. It would be an anathema to the concept of constitutional adjudication if the speaker is allowed to initiate proceeding under the 10th schedule of the Constitution after intention to remove him from his office is moved, the 14 days period being mandatory. The word all then members gain more significance, constitutional confidence in the speaker, and then, my lord, actual real figure. I just leave it at that. So, my lord, therefore, there is no absence of a clear prescription of the commencement of the process of operation of the bar against these people.
All right.
I'm deeply
Thank you,
obliged.
Mr.
That's what I want.
Can I just add?
My lord, only one thing, my lord. I have filed a note.
We got
Which
it
has been,
Got,
my lord,
got your mode.
last night.
Yes.
that's all, my lord. So therefore,
Got the note.
the lordship may kindly consider that note, my lord. I will not take more time.
I take very little time at all. In fact, I have not yesterday circulated a note in volume 8 that place the points. I am not showing your lordship any documents beyond that. It is in volume 8. These are my written submissions in 8 pages. So I'll just place the point for volume 8.
Yes.
If your lordship has it, I'll just place this here.
Yes, Mr. Bhatnagar. Yes, Mr. Bhatnagar.
This is only in addition to and without prejudice to what has been stated, so I will not repeat it. My first point, my lord, point is, the point is stated like this. The interdict on the speaker as per Navam Revia is for a very finite, limited period and is needed to ensure the speaker cannot kill the voting membership of the House. For this, the analysis I am proposing before your lordships is this. Rule 11 is said
It is 14 days, if you really look.
No, I'm saying something else. Please turn over the page, just see this. Kindly turn to page 2, just see my analysis if it appeals to you. On rule 11.
In A, you have said exactly what I said. The interdict is 14 days.
The interdict is 14 days.
After 14 days,
Yes.
that 14-day period, the speaker cannot curtail by saying that, look, it was for my benefit.
That's correct.
Period is also for the members to gather these.
Well, the reason I'm saying.
After 14 days,
Yes.
the rule says as soon as maybe.
As soon as
He can convene it on the second day.
Correct.
Once leave is granted, he has not more than 7 days.
That's right.
He can convene it on the
Correct.
next day. So essentially, what Nabam means is that for 14 days after the notice to remove is issued to him, he cannot then preside over the motion.
Your lordship.
So the period really, when he is disqualified, we'll say disabled.
Disabled. Is 14 days.
14 and.
Now, just to add to what your lordships have said, in that 14 days, one of the arguments of the other side was, what if a member does not move a resolution after that 14 days? I wanted to take care of that argument.
What is your answer?
Which is why para 2 may be kindly seen. This is the summary of rule 11 of the Maharashtra rules, and the Lok Sabha rules are identical. Please see, my lords. Now I am placing A to E. The motion to remove a speaker requires a period of at least 14 days. Your lordships have said so. Now B. After the expiry of the period, the notice is read to the assembly by the speaker as soon as may be after the expiry of notice period. At this stage, there is no second notice or resolution contemplated to be moved by the member. Then the speaker requests for 29 members to rise. So I am saying that the member who has moved the resolution cannot delay the voting on the motion or leave being granted at all. Now please see how the speaker is further protected, Lord. Please come to para Roman 4 of my note at page 2 again. Here I have set out, Lord, rule 45 of the assembly rules. Again, Lok Sabha is identical. Please see the rule. Subject to provisions of rule 109, a motion shall not raise a question substantially identical with one on which the House has given a decision in the same session. So you cannot have repeated motions to interdict the speaker or to disable the speaker. So it is only 14 days in the session itself. Now, my lord, please see 109, which is the next rule I have quoted. Roman 6. When a resolution has been moved and voted upon, no resolution or amendment raising substantially the same question shall be moved within 1 year from the date of voting upon the earlier resolution. So for 1 year, the speaker has no problem. So it is actually just that 14 days for once in a year at best. If it reaches the stage of voting, and if it does not reach the stage of voting, only 14 days, a member cannot stop it at all. It's outside the hands of the member. Now, my lords, kindly see, now I'm just reading for your lordship's convenience, para 7, which is my submission. Thus, if a resolution is moved and voted upon, no resolution dealing with the same question is permitted to be moved within 1 year from the date of voting upon the earlier resolution.
That's the protection, that you can't keep on repeatedly moving that.
So that is one part of it. Now, my lord, now also consider one further argument. Suppose it is moved on the last day of the session.
It lapses.
It immediately lapses under Rule 20. I've said so at Roman 9.
Rule 20 we saw yesterday.
Yes. Now, my lord, I have also quoted for your lordship's convenience identical rules of the Lok Sabha, which say the same thing. Now, Lord, I'll just add to one more. My second point, Lord, is, which has already been argued, that by deciding vacancies, what is happening, the speaker is deciding vacancies, and the people who vote for him is total membership minus vacancies. my lord, on reading Article 190, which I suppose your lordship would have seen also, apart from 191, 190 of the Constitution is vacancies, which refers to a vacancy created by disqualification. And the people who are voting for the speaker or not voting are total membership minus vacancies.
All right.
And my lord, lastly, I'll just
Got your
end,
point.
my lord, I'll just end with one last point.
Yes.
Just in addition to this, my lord, if your lordship, since your lordships have read Navam Rebi at great detail, your lordship will find that what pervades the reasoning of Justice Mishra particularly is actually constitutional morality as well, which is my point C. So, my lord, and my lord, at that time, Manoj Narula was the law which he cited. Thereafter, Institute of Delhi, etc. is coming. So, a constitutional functionary, namely the speaker, cannot, my lord, act in a manner which is against the spirit of the constitution.
Thank you.
This is my third.
Thank you, Mr. Bhattacharya. Yes, Mr. Sibal.
I won't take long, Malas.
Yes.
Deeply obliged.
No intention to cover your lordships too much, Malas. Malas, just, Malas, the 10th schedule was incorporated in the Constitution in 1985. 179 has been there before, Malas.
Yes.
So, Malas, well, there was no 10th schedule, yet you can ask for the removal of the speaker. For reasons that had nothing to do with the 10th schedule. So, first question, if you seek a removal of the speaker, which has nothing to do with the 10th schedule, is he barred from dealing with disqualifications? Makes no sense. We are arguing as if the only reason for removal is the 10th schedule. Well, any number of reasons for which a speaker can be removed. So he'll be debarred to perform his adjudicatory function. Ex facie, a wrong proposition of law. Ex facie. In fact, Maharaj, 179 operates in an entirely different field. That's why the 10th schedule uses the word disqualification and 179 uses the word removal.
So if the Nabam principle is right, then once a notice is given of an intent to move a resolution to the speaker, not on the 10th schedule, but for any other reason, so long as the motion is pending.
That's right, the motion is pending. How does that, how will this argument be? You would then have to make a distinction under 179 itself, in interpreting 179 read with the 10th schedule?
No, but logically, Mr. Sibal, the argument of the principle in Nabam will extend irrespective of what the cause for the...
I agree, but that's what I'm arguing about.
That's right.
That's precisely what I'm arguing.
Because once the principle which Justice Mishra seems to have laid down is that once, and Justice Kher also, that once a notice for your removal is given, then, then there is a...
But there is a
except for one thing, I'll tell you what. In case of the 10th schedule, there's one additional factor. That when the speaker acts to disqualify somebody under the 10th schedule, he is affecting the majority in the electoral college which will decide upon his removal. Right?
Correct, but that's fine.
Suppose a speaker is supposed to be, sought to be removed on the ground that, well, for whatever behavior in the house. They say that, well, you have not given the opposition sufficient time to speak, or you have not been even-handed. Just hypothetical. In that case, there is no conflict of interest as such. That conflict of interest is taken care of by 181. Namely, that on that day when the motion comes up for consideration, you will not preside. You will have a right to vote.
That is motion to remove him.
Motion to remove him.
Absolutely right.
But there's no question of the speaker affecting by excluding certain members of the legislature.
I agree.
Because here what happens is the moment you rule on the disqualification, you are affecting the balance or composition of that body which will vote.
I agree entirely with your lordship. Therefore, but 179 will still have to be interpreted in any situation. You can't ultimately you'll have to say that 179 in this context will not operate.
No, that you see the Constitution lays down the principle in regard to the overall conflict of interest in 181.
Yes.
Irrespective of 10.
Irrespective of whether it's on the 10th
That's-
schedule or otherwise.
I am saying that.
But on the 10th schedule disqualification, our court has introduced an additional.
But that's the problem. You know, that is the problem of the case. But
Your argument, Mr. Sibal, your argument that the same principle will apply to any motion for removal may not strictly be right.
But Malad, that the Nimam Rabia doesn't say so. Your lordships may interpret Nimam Rabia like that. But Nimam Rabia doesn't say so, Malad. We are now saying you will have to clarify it. You clarify it by referring to 7. I'm on the principle, Malad. I'm not arguing the merits here. I'm on the principle. Nimam Rabia doesn't make that distinction. Your lordships may wish to make it. That's another issue. Malad, let me just move. This is one issue. Number 2. But in fact, 179 was incorporated in the Constitution for the removal of the Speaker because removal involves a stigma for cause. And therefore, you will see in the constitutional provisions his right to participate in the House and defend himself. It was nothing to do with the 10th schedule. You see the provisions 179, 181. He will, at the time when the motion is moved to remove him, he'll preside over the House.
Actually, you're right. 179 and 181 have nothing to do with the 10th schedule.
Exactly.
Because that's why when the 10th schedule came in by the 50th constitutional amendment,
Yes,
they recognized that in 191.2 and 102.2.
that's right.
But they didn't amend the provisions of 180, 179.
That's correct. That's correct.
They left it intact. What's the reason? Parliament left it intact.
There's a reason why they left it intact. See the proviso. See the proviso to paragraph 6 of the 10th schedule. The proviso to the 10th schedule, paragraph 6.
Then
Yes.
Just for the matter, we have got several members of parliament over here in any case. Normally, when a 10th schedule petition comes for disqualification, the 10th schedule itself doesn't indicate how much notice has to be given to the member.
No.
That will come under the rules.
Under the rules.
and every
That is why courts have said rules are not mandatory, Malaz. I'm not on the merits, Malaz. My learned friend argued the merits. We are not on that.
I was not on that. I was for another reason.
Yeah.
That technically, then a speaker, the next day after a petition for disqualification is presented to him, in a day or two, he can say, I'm disqualifying you, right?
Yes.
Technically,
Technically
a speaker may do that.
That he can. I tell your lordship the reason. I give your lordship the reason. Supposing, Malaz, the House is proceeding, a whip has been issued, and 12 people defy the whip. Just because these are live examples, 12 people defy the whip. Normally, what's the need for a notice? It's on the record.
It's like contempt in the face of the court.
Exactly. It's on the record. Somebody files an application that I am seeking your removal. So under Navan, he can't deal with it.
But then the legislatures have made rules, provided that the 7 days notice is to be given, though it's interpreted as
Not
Dr.
matched.
Singhvi is saying.
Normally it is 7 days.
But then there is a Karnataka judgment, a 3-judge bench.
Then Ravi Naik.
Not Ravi Naik. It's Shantanu Gowda, Justice Nazir, and Justice Boppana.
Yes.
All three of them have come here. The question there was whether 7 days notice, 7 days was not given. But then the court held there
3 days enough.
that not necessary. But then this court has reversed it in a subsequent judgment. This court has held the legislature has made a rule 7 days
That's Yediyurappa.
has to be followed.
That's Yediyurappa. That's been distinguished in another case. But as I said, we are entering into the merits of these issues, which we are not at the moment concerned with.
You must be aware.
No, it has one very important bearing.
You only made rule.
That why do you attach the disability on the speaker the moment a notice under 179C can be given? The reason is that there is no real power or restraint on the speaker in proceeding with the greatest of alacrity on the disqualification.
But on the other hand, Manoj, when there is a disqualification,
That seems to be the logic.
that's right. But on the other hand, when there is a disqualification,
It's so difficult. It depends on.
he has to proceed with alacrity. Otherwise, the government will be toppled. Manoj, kindly, there are two issues here. What has happened today is, Manoj, somebody goes to Gujarat, goes to Assam, passes resolutions, removes people, Manoj, and that is not considered to be
That my
disqualified.
learned brother just mentioned, if with his permission I'll share. It's not always that the speaker will act with alacrity to disqualify. In a given case, he will be sufficiently emboldened, or he may decide not to take a decision also.
That's right, Manoj. We have seen that in Goa. We have seen that in many other places.
It works. It
When
depends on which
it
way.
depends on who is in power.
Exactly.
Exactly. So, Manoj, therefore,
Sometimes you want to take an early decision.
Manoj,
Sometimes you have to
The
let
court to lay down, it's
let-
very difficult because,
Very difficult then.
very difficult. In fact, 10 schedule, each case is a history in itself. So therefore, to formulate a principle with respect to at what time the speaker is to act and lay down as a principle is difficult because, but then legislatures and parliament has made rules with respect to when he should act.
no,
So that
Manoj,
discretion is a problem.
Manoj,
In one case, he will act.
at the moment, we are only concerned with one issue. Whether at the time of issuance of notice, the disqualification to preside occurs. That's the only issue we are concerned with. We're not concerned with any
Then
other
the
issue.
problem, only answer to it is whenever at whatever point of time the case is finally decided by the speaker, it will relate back.
Yes.
If it relates back, all this is irrelevant.
No.
If it relates back, all this is because even now.
No, it won't relate.
Taking this very case, Mr.
Manoj, in the
If he
meantime,
decides today if your argument is to be accepted, it always relates.
Manoj, but in the meantime, a legally elected government has been toppled by virtue of the fact that the disqualification has not been decided. So,
I'm
Manoj, is it,
answer to your-
Manoj, the fruits of the poisonous tree are being enjoyed by somebody else?
I'm
Manoj?
replying to your submission only.
I'm
that-
sorry?
That it should relate back to that. I'm saying the answer.
No, that's all right, but it will relate back after 2 years, relate back after 3 years.
Relate back, because I had argued in the context that your lordship would then allow a disqualified MLA or MP to be able to do something. If it relates back, that is that person who is given the notice is himself disqualified. He can't, that is the context in which he is arguing. That your lordship cannot then allow him to have the status of a person who can give a notice.
Well, let's take in this case Eknath Shinde, who is the chief minister. He is the first person, he is one of the 16. How will he going to relate back? In the meantime, a government has been toppled. So, Manoj, these are very vexed questions that your lordships will have to look at Raman Bebia and see how to answer
Mr.
them.
Sibal, there's another aspect also of Nabam which has been worrying us. We've been in discussion. which is that ultimately in any constitutional adjudication, Nabam lays down a principle. Now, we have seen how vexed it can be in the sense that, it really depends on the emerging political situation from case to case, states to state.
That's true.
Now, Nabam has laid down a principle which is holding the field until today. Before we decide to enter upon this to review the correctness of Nabam, we must also be clear that it, strictly speaking, arises in a case. Now, one thing which you have to really perhaps assist us on is this. Nabam, the correctness of Nabam would arise if the speaker stood injuncted either by the High Court or by this court from exercising his powers under the 10th schedule. If the speaker was injuncted from exercising his powers under the 10th schedule until the vote for his removal was taken up.
Right.
Or he himself says that, look, in view of Nabam, I'm not going to exercise my jurisdiction.
Right.
Then somebody else may say that, well, you have to exercise that jurisdiction. Now, in our case, what happens is that when the speaker perhaps in that sense created a problem for himself, maybe out of the political exigency. We're not at all saying that in a pejorative sense. That's real politics. The speaker himself gave only 2 days notice. 25th, he said, I'm going to give you time until the 27th. Our court, in the light of that, said that time to furnish your reply is extended until the 12th of July.
In the interim, Your Lordship may not have looked at that phrase.
Yeah, in the interim.
In the interim,
Now,
it is
every
extended.
time a trust vote takes place.
Yes.
The then government decides not to face the assembly, it resigns.
Right.
Therefore, what impact the vote or non-vote of these people who were sought to be disqualified by the speaker would have was never tested on the floor of the House.
No, it on the 4th it was tested.
The resignation.
On the 4th it was tested.
No.
Yes.
On the resignation of the Chief Minister obviated a reference, obviated the floor test.
No,
Therefore,
it happened. It happened on the 4th.
On the 30th itself.
For Shinde it happened, the same thing.
No, but on the 30th, what happens is this. On the 30th, when the floor test is to take place, the government resigns on the 29th.
Right.
The moment, of course, they got to know that the floor test is going to be held and there's no stay by the Supreme Court. Now, as a result of that, what happens is that the consequence of the vote, which would otherwise have been cast by a person who was sought to be disqualified on the overall voting pattern, never emerges before the assembly. So, in which case does the correctness of Nabam Rebia fall for consideration?
Yes, Manoj, I will demonstrate that immediately. Manoj.
And should we go into the validity of Nabam Rebia merely because obviously very interesting constitutional issues arise? Because when we decide a constitutional issue in the absence of a factual background,
The factual background,
that the court is trenching upon something without full facts.
Kindly then look at the notice, Manoj. Twice it has happened. On the 3rd they voted, on the 4th they voted. 3rd they elected a speaker. 4th, Manoj, the trust. Defying the whip, defying our whip. Because Manoj, the whip had not been changed by them. That was changed. Gogagare came in on the 3rd night, Manoj. So all that is before you now. But be that as may, let me answer a more fundamental question. Let's kindly look at the notice of the 22nd of June that my learned friends have been relying upon. Convenience compilation, volume 2, PDF page 62.
22nd June. 22nd June.
22nd June, but dated 21st of June. Yeah, I know.
Convenience compilation 1, right, Mr.
Yeah, two, compilation 2, Madam. It's a very interesting document.
Page number, page number.
Page number PDF 62, otherwise 49. Just mark one date, Madam, in your mind before we read this document. 23rd of June, petitions are filed for disqualification.
Once more, that date is?
23rd of June,
Yes.
petitions are filed for disqualification. 25th of June, speakers issues notice for 27th June. These 3 dates.
Correct.
Give me just a moment.
Will you please repeat yourself, Mr. Sibal? 23rd June, petition filed.
Petition filed for disqualification of the 16th. 25th of June, deputy speaker issues notice. There's no speaker. For 27th.
Correct.
27th, this court passes that order. Now, let's kindly read this notice of dated 21st June. And if your lordships has the document, and kindly see on the left-hand side, 22nd June, 2022, 11:33. So it is received by the deputy speaker on the 22nd, but dated the 21st. Obviously, Malaj, they have.
Yes, it is received on the 22nd.
Yes. It's received on the 22nd, it is 11:33. Now, Malaj, the last session of the assembly, which was the budget session, took place from the 3rd of March to the 25th of March, 2022. Now you see the mischief, Willis, when we read 3rd of March to 25th of March, 2022. Now see the mischief, Willis. Just read this notice. You were elected as Deputy Speaker of the Maharashtra Legislative Assembly on November 19. Since February 21, due to resignation of Nana Patole from the post of Speaker, you have been discharging functions of Speaker of Maharashtra Assembly. We all respectfully submit that you no longer have the right to continue as Deputy Speaker, as you no longer enjoy the support of the majority of the House, and more particularly the following members of our party. In well-known judgment of the Honorable Supreme Court in Navam Rebia, it has been held that if the Speaker and or the Deputy Speaker rightfully and truly enjoys the support of the majority, there would be no difficulty whatsoever to demonstrate the confidence with which the members of the state legislature repose in him. In your case, you do not have the requisite. Further, under 179C, Speaker can be removed from his office by a resolution of the Assembly. We members of the Sena Legislative Party constitute 34 members and therefore are issuing the present notice under Rule 11 for your removal. Right, Manoj? Numbers? Meanwhile, we request you to refrain from discharging your functions as Deputy Speaker with immediate effect. There was no disqualification petition. Reference to Navam Rabia. There is no disqualification petition filed. There is no notice issued. How is this academic?
The reference says that notice to move a resolution for removal. Just come to page 49.
That's correct. Correct.
Isn't this that?
On what ground?
No, that's a different matter. You are saying there is no rule.
No, I'm saying then you cannot discharge your functions, he says at the end.
That's a different matter, that what he can do. But then I'm talking about the notice. You're saying there is no notice. It's actually a notice, right?
Para 5 says we are members of the Assembly, and therefore as issuing the present notice, it is notice of disqualification.
Hereby call upon you to move the motion for your removal.
That's right, and under Rule 11, and then says that you are now, therefore you can hold your hands, you cannot deal with anything, because they know that a disqualification petition is going to be filed. Therefore they preempt it. There was no notice on that day, there was no petition on that day. And how is therefore Navam Rebia an academic exercise here? And how did they rely upon Naban Rabia?
This disqualification petition on the 23rd, right?
Yes. Afterwards, obviously, they wanted to paralyze his functioning. The whole intention.
No, Mr. Counsel, Nabab Raja is referred to for a different purpose, not with respect to disqualification. Please read para 3
Yes,
of that letter.
yes, yes.
It is referred to for a other person.
Yes.
Other reason that in Nabam Raja it is observed that the speaker, so far as speaker is concerned, so and so, so and so, so and so. It is not with respect to disqualification to continue the tense candidate. No, we are on your submission that at that time there was no confidence.
Rabia only deals with disqualification.
Now please see para 3.
I am reading paragraph 3. It is the speak.
It is well known in the well known judgment. That is what he is saying.
I am not disputing that. If your lordships, I think that by now your lordships have just sufficient experience to read and understand what it means. And what it means is that you don't please proceed further in the matter. It's obvious. It's so obvious. I don't have to elaborate it. Read the last line of the notice. We request you to refrain. Where is that? We request immediate effect. What? The deputy speaker function is also under the 10th schedule, Maharaj. I mean, let's not.
You're reading Nabam in para context.
We understand.
Go ahead, sir.
Let's be clear. And you can't discharge your functions as a deputy speaker. Means I can't discharge under the 10th schedule. So that's
Your
clear.
simple point is that there was no complaint under 10th schedule. Where is the question of a notice given?
Exactly. And how is this academic? The whole purpose of it was to paralyze the speaker. Purpose of it was to ensure that I do not deal with the disqualification petition when it comes. And they knew it was coming. In politics, there is no secret.
There was already
What happens, at one end is known to the other person. So somebody must be drafting the petition, and they must be knowing it. And let's draft a letter dated 22nd, date it 21st, and send it to them. This is practice.
Obviously, everybody knew what was going to happen.
So,
who doesn't
say that this all is
they are times ahead of times to come.
Yeah.
It's all. Who doesn't know? Even citizens know about it. Forget about legislators.
That's right. Even citizens know. So therefore, let's be clear. The whole initiation of the exercise.
The 10th schedule now has been internalized by the political establishment. So they knew exactly.
I said that in my opening. It's
been internalized. They also knew exactly what's going to happen. It's like everybody is, it's like a chessboard. Everybody knows what's the next move.
Now, let's look at it from another standpoint. I'll come to the 10th schedule later.
Yes.
Another standpoint. Well, it's under the 10th schedule now, even if the majority defects, it will still be defection. There is no concept of majority, minority under the 10th schedule anymore. The only concept is of merger.
Merger, that's the only thing.
So to say that the majority, we are 40, is no defense under the 10th schedule.
But this is not a case of merger also, as
it's
Paul is saying.
It's not their case of merger. So to say, I've been hearing this refrain that we are 40, they are, it makes no difference. That is why para 3 was removed. These are very serious issues. You can't apply Naban Rabia in this fashion. And therefore, my lord put it to me, if you have lost the plot, we have not lost the plot. Because the 10th schedule itself allows me. There is no defense available. Which is why they don't want this to go on. Which is why, Maharaj, they are saying it is academic, don't deal with it. Our speaker will decide. Now we have a new speaker. Maharaj, and now we can't remove him because they have the majority now. So even if we give a notice, we can't remove him because they've toppled the government. See the serious consequences of this. And what moral principles are we talking about, Maharaj? Maharaj, these are not conscientious objectors, Maharaj, like in Soviet citizen wars, Maharaj, in Russia. These are conscientious defectors, where they lay their conscience on a platter and depends on who bids the highest. Let's not make these moral principles in this. We know what happens. So, please, Maharaj, please, I beg of you, this is not about today. This is about tomorrow. Don't board the issue, Maharaj, and say it doesn't arise. It will arise time and again. Elected governments will be toppled. And no democracy in the world allows this to happen. Why do you allow the party to use the 10th schedule? In fact, the process must be, this is my Maharaj, and when I argue the merits, the process must be that an elected government must continue till the disqualification petitions are decided. If they are disqualified, that's the end of the matter. Your Lordship is there to protect them. If they are not disqualified, the elected government will go. But do not allow the 10th schedule to topple an elected government. And do not interpret 179, 181, the moral principles that Justice Mishra talked about, to allow this to happen. It's far too serious. It's not just, I'm sorry, it's not just a narrow interpretation.
Sorry? Yeah. Yes.
So let's kindly see. Look at the Lok Sabha rules on removal of the speaker. Because it's part of the compilation. Please see.
Mr. Sibal, ultimately, equally, what your submission is, therefore, give free rein to the speaker.
No,
Free rein to the speaker.
No, Maharaj.
Without imposing any restraints.
No. Please don't do that. And I'll tell your Lordship what the solution. What's the free rein, Maharaj? He cannot deal with a disqualification unless there is a disqualification petition. He has no right to suo motu deal with it. Maharaj, the disqualification petition will come under 2(1)A or 2(1)B. 2(1)A, if he violates the whip, Maharaj, what's the free run for the speaker there? In this, what happened? On the 3rd of July, at the time of the election of the speaker, the whip in the house was Sunil Prabhu. He had not been changed. He directed that the Shiv Sena candidate should be voted for by these defectors. They voted against. They elected the BJP candidate, not the Shiv Sena candidate.
Interestingly, both your argument and the argument of the other side, which espouses the Nabam principle, rely on the same principle, namely the importance of the speaker. They say, because of the importance of the position of the speaker, it's important that you must exclude any possibility of conflict of interest.
But where is the conflict of interest?
You say that in view of the importance of the position of the speaker, allow him to decide.
No, I say don't allow an elected government to be toppled in this fashion. Maharaj, no. Don't allow the verdict of the people to be toppled or an elected government to be toppled in this fashion. That's the fundamental principle. A government stands elected till it is removed, and it cannot be removed through the machinations under the 10th schedule. That's my contention. Maharaj, forget about the speaker or no. This is the fundamental principle of democracy. And if you have violated the 10th schedule, allow the speaker to decide. Maharaj, he can't decide contrary. If there's a whip, Maharaj, that has been issued and somebody votes against the whip, what leeway does the speaker have? You are giving a leeway to the other side, disabling him, toppling the government, and then not deciding the matter. I remember, Manoj, when the Rajasthan matter came up on this court, Justice Arun Mishra, on a daily basis, used to monitor the disqualification proceeding. On a daily basis, when it came to Rajasthan. When it came to Goa, for 2.5 years, we kept on telling the Chief Justice, please have the matter heard, please have the matter heard. Where do we go? These are all nice principles of law, but you have to have a functioning, working democracy. This is why it's far too serious, Manoj. The fundamental principle is keep an elected government that is already elected in place, keep it in place till such time as it can be thrown out. Of course, it should be thrown out, Manoj. And that is not to be decided in the legislature, Manoj. Kindly appreciate what is happening. Manoj, this is another very interesting thing. And it's something that your lordship should think about. 5 people in Goa, say 2 of them or 3 of them, Manoj, are taken over by another party. The government falls. Or 4 of them are taken. The argument is that under the principle of merger, since they have merged with another party, right? Now, what is the party? The Congress party still remains. Those 3 of only legislators have merged. The party still remains. It happens in the Rajasthan also. The BSP people, Manoj, have merged, but the BSP still remains. So what we are now doing, we are allowing the manipulation within the Legislative Assembly to topple governments through means that your lordships and I are aware of. The purpose of the 10th schedule was not to allow that to happen. Not to allow that to happen. That was the purpose of the 10th schedule. Previously, it was 1/3 in paragraph 3. They said we removed the 1/3 because it was being used to topple governments. Now there is no paragraph 3. Now a bogey of majority is raised. Because if a minority can be bought, majority can also be bought. But to what end? To topple the government. And not to allow the speaker to decide the matter. Whereas who can say, person sitting of one party in Guwahati, saying that he has not voluntarily given up membership of the party, it stares you in the face. He is passing resolutions from there that I remove you from chairmanship, I remove you from this office, I remove you from that office, I appoint myself. That's not supposed to be voluntarily giving up party. They are all arguing on the assumption that they are right when they say that there can be no disqualification for these acts. That's how they are arguing. And that the speaker, deputy speaker will malafidely say that they stand disqualified. You can't make a constitutional assumption like that. That's the assumption they are making. See what the speaker is doing. He only gave us 2 days notice. Why did he give you 2 days notice? Because the facts stare him in the face. That's the reason for the 2-day notice. Now, your lordships, when dealing with the merits of the matter, will decide whether that was enough, not enough in the facts of the case, but that's on merits. But the issues are far larger. And if this is allowed, it can happen anywhere, and it will happen. It has happened. This is not the first time. Now, having said that, kindly come to the 10th schedule for a minute. Yes. Yeah. Yeah. Paragraph 6. If I may, I'm sorry.
Yeah.
The Constitution. If any question arises as to whether a member of a house has become subject to disqualification under the schedule, The question shall be referred for the decision of the chairman, or as the case may be, the speaker of such house, and such decision shall be final. Provided that where the question which has arisen is as to whether the chairman or the speaker of a house has become subject to such disqualification, not removal, the question shall be referred to for the decision of such member of the house, as the house may elect in this behalf, and his decision shall be final. The constitution makers were aware of the difference between removal and disqualification.
Yes.
They were aware. They never incorporated, as your lordship has said also. When the amendments were taking place during this time, during the in 91, 93rd Amendment, they never incorporated any of this. And the reason was that when you talked about removal, it was an entirely different regime. And I show that to your lordship's mother, just refer to the Lok Sabha rules. Volume 3B. Page 23. Give me my iPad. Chief Justice will tell me I'm not using my iPad, so I better use it.
Lok Sabha rules are there.
Resolution. Yeah. It's clearly evident from here. Yes, kindly see, Malas. Yeah, please. Resolution for removal of speaker or deputy speaker from office.
Page,
Where are those rules?
page.
3B, Malas.
Yes, it is compilation. What are the?
Compilation 3B, PDF page 26.
Very similar.
This is what
Yes, yes.
explains.
Yes, now, if you give me that.
200.
Now, let's kindly see resolution for removal of speaker or deputy speaker from office. Your lordship has that? 200. A member wishing to give notice.
What's the PDF page?
Page 26. 26.
Yes.
Now, let's see on the right-hand side, the bold part. That's the note, notice of resolution for removal of speaker or deputy speaker. That's just notice. A member wishing to give notice of a resolution under clause C of Article 94 of the Constitution for the removal of the speaker or the deputy speaker shall do so in writing to the Secretary General and shall furnish the full text of such resolution. On receipt of a notice under sub-rule 1, a motion. So that's first is notice, then a motion. My Lord, in fact, Justice Narasimha was actually rightly bifurcated that rule in that fashion. On receipt of a notice under sub-rule 1, a motion for leave to move, the resolution shall be entered in the list of business in the name of the member concerned on a day fixed by the speaker, provided that the day so fixed shall be any day after 14 days from the date of the receipt of notice of the resolution.
There is 179
day notice. So, first the notice, then a fixed day for motion. Then, in order that such a resolution, so first of all, notice of resolution, then admissibility of resolution. That's the third stage. In order that such a resolution may be admissible, it shall satisfy the following conditions. Namely, it shall be specific with respect to charges, because removal involves a stigma. That is, Constitution uses the word removal, not a no confidence. But as your lordship knows, in a no confidence motion, you don't have to give a reason. Well, the House votes and you are out. But in the case of a removal, you have to give reasons. You don't say nabam rebia. In fact, this petition could never have been filed against Malats on 27th, on 26th for an order on 27th. This is no notice in the eye of law. But that's on merits. I'm not going to go into that. Then it shall be clearly and precisely expressed and it shall not contain arguments, inferences, ironical expressions, imputations, or defamatory statements. Then 201. Subject to the provisions of 96 of the Constitution, the Speaker or Deputy Speaker or such other person, as is referred to in Clause 2, shall preside when a motion under sub-rule 2 of 200 is taken up for consideration. The member in whose name the motion stands in the list of business shall, unless makes a statement conveying unwillingness to move the motion. So, this is the point I was making. Even when the motion is in the House, he may not be willing to move it. So there can be no injunction for him to continue with the 10th schedule and the proceedings. Because the resolution, let me tell you, I have some experience in Parliament, let me tell you what happens. Whereas what happens is that whenever a resolution...
But according to you, there can't be any injunction at all, irrespective of the stage of the motion. Right?
Yes, because that is to him. This third 10th schedule...
Even if it is admitted, there is no bar on the...
No.
Even during the 7 days.
Yes. Well, I tell your lordships why. Well, the 10th schedule deals with strangers. The motion deals with him. The 10th schedule deals with third parties. The motion deals with him, so he cannot preside on that particular day when it's under consideration. Well, what has got to do with third parties? Now, these issues were never discussed in Nabam. That's why Mavlankar says that there can be no... There's no specific... That's why Manas is allowed to participate in the proceedings of the House. He's allowed to speak, he's allowed to vote.
Yeah. Yes, Mr.
Manas, kindly continue to read this, Manas. So I was reading too. A member in whose name the motion stands on the list of business shall, unless makes a statement conveying unwillingness to move the motion when called upon to do so. But in either case, no speech shall be permitted. Now, Manas, he continues to preside over the House. The Speaker continues to preside. Then the Speaker or the Deputy Speaker or the person presiding, as the case may be, shall thereupon place the motion before the House and shall request those members who are in favor of leave being granted to rise in their places. Even then he is presiding. Right. Sorry. If not less than 50 members, as I told you, there's 29 there, rise accordingly, the Speaker or the Deputy Speaker or the person presiding, as the case may be, shall declare that leave has been granted and that the resolution will be taken up on such day, not being more than 10 days from the date on which leave is asked for, as the Speaker or the Deputy Speaker or the person presiding, as the case may be, may appoint. If less than 50 members rise, the Speaker or the Deputy Speaker or the person presiding, as the case may be, shall inform that the member has not the leave of the House. On the appointed day, the resolution shall be included in the list of business. Then it becomes under consideration. On the appointed day. That's why I was telling your lordships my experience in Parliament. What happens is, supposing there's a bill, forget about this removal. there's a bill, Malad. What do? We stand up and I say, do I have the leave of the House to introduce the bill? The House is asked for, the leave is granted, I introduce the bill. But it's only introduction. Then, Malad, the matter goes to the Business Advisory Committee. In the Business Advisory Committee, after discussion with everybody as to when you should bring the bill up, Malad, then a date is fixed. Then on that particular day, Malad, some other matter may be going on, Malad, it doesn't come up, it goes on to the next day. Then, Malad, when it comes up on the next day, we rise in our chair and we say that I propose to move the bill for the consideration of the House. That's when it's considered. The same procedure applies. So this whole argument at the time of the problem with Nabam is it says the moment the notice is given, you can't function. That's what Nabam decides for us. Therefore, these rules are all ultra vires according to Nabam. Because he can't preside. So these are serious issues. And there are live issues, these are not dead issues. Especially in the context of that letter, notice on 22nd, dated 21st. The idea was not to allow the speaker to function. The whole purpose was that. Now your lordships put to me, but then it's a free, and rightly so, that the speaker has no impediments in his way to decide the matter. But that's what Holohan says. What does 110 of Holohan say? There can be no legitimate action before he decides. That's 5 judges of this court. Therefore, the 27th order could not have been passed. Your lordship put it to me that no, he only adjourned it. In the interim, I adjourn it. I give them time to file a reply. What does in the interim mean? You extend the time, I can't decide. What else is it except stay? What else is it except violation of para 110 of Nabam Rebia? What else is it but it's a quitamate order? Can you put it in any other framework? No, I'm sorry. So Nabam, Holohan says you can't interfere. If you can't interfere, then the speaker has to decide. And the whole problem arose because of the 27th order. That's a live issue. That's not a dead issue. That's not academic. Because it was on 2 grounds. Nabam Rebia and 2 days notice. So if that was bad, everything will go. Because then what it catapulted into a situation where an elected government is toppled. Because of the disqualification of the deputy speaker not being able to decide. So my respectful submission to your lordships is that 179 for removal operates in an entirely different field. Now I must also disclose to your lordships that the Maharashtra rules do not have this what the Lok Sabha rules have.
So what do we, the flip side, Chief Justice,
Yes.
situation where it's not really a case of an anti-defection. It's a case where there's perhaps a realignment, even a starker case than this, where there is actually realignment is going on. And the chief minister is in an awful minority. Then knowing the writing on the wall, the speaker would want to declare all the others who are on the other side as violative of.
He can't unless there's a petition before him.
That's another.
Yeah.
Petition part of it is what you are saying, this application, this notice is actually not equivalent to a petition. We are on the interpretation. We are on the question of should the speaker restrain or postpone it till some point of time. We are only on that question. In a situation like this, in order to preempt a situation, speaker takes up the matter and immediately disqualifies them.
Let me answer that. Very pertinent question. Let me answer that. Let's now bifurcate these two. One, you can't have a notice before a petition for disqualification. That's one part. You can only have a notice after the petition for disqualification.
Okay, that point is taken. Well,
Correct?
go to the
After
next
the
point.
notice.
What's the next
Now,
point?
supposing there's a notice after the petition of disqualification. In that event, everything would have happened already.
Suppose there is a
The
notice.
facts would have happened already, because the notice will have to be based on
Take a
allegations based.
situation where a notice is there. Take a situation. Assuming for a minute that this 20, instead of 21st, it's a 20th notice. Then what will
Makes no
happen?
difference. Not 20th, 24th.
No, there is a notice on 10th schedule
Yes.
already given by one of the minority members. Then what will happen?
I'll tell you, Lordship, what.
Then the speaker proceeds further to disqualify all of them.
Why not? Because that's the law. That's why I said under the 10th schedule, there is no majority issue. There is only a merger issue.
So therefore,
There's no defense under the 10th
in
schedule.
about 2 days' time, he proceeds to consider the 10th schedule and immediately he passes.
But Malaj, if out of 55 or 58, 40 are on the other side, it's covered by the 10th schedule. Because there's no defense. Malaj, as your Lordship knows, under the 10th schedule, you are given only defenses. If there's a petition for disqualification, there is only a defense available. It was available, Malaj, under paragraph 3, 1/3 of the members of the legislative party, Malaj, decide to join the other. That was a defense available. We are 1/3. Right? Now, that also has gone. So there is no defense of saying, I'm in majority. Your Lordship is now taking a hard fact situation that the Chief Minister has lost confidence. Actually, he's only 50 people are, out of 50, 40 are on the other side. I assume that against myself. Right? Now, Malaj, they are still subject to disqualification. So what? That's why, as I said, these majorities can't be decided in the legislature. What they'll have to do is go to the party, take over the party, throw him out, and come to the house.
No, all that time is not there. By the time they go to the party, to the election commission.
Because that is why, Malaj, that is precisely my argument.
Therefore, Mr. Sibal, your argument, I mean, stretched to its logical conclusion would mean this, that even if a chief minister of a party completely loses the confidence of his own party in the house,
Yes.
whether he has a confidence or not cannot be tested on the floor of the house.
It cannot be.
Which means that, according to you, therefore, that a chief minister and a willing ally in a speaker.
Malaj, the speaker will have to be with him. At least two people will have to be.
People have to be. There are two of them. You can spot because we're not dealing with a defection.
No, I understand.
Where you lose your own party,
But
but then you continue because you have lost your own party.
I tell your Lordships, then what will happen? It's very simple, Malaj, then what will happen? Then what will happen is that under the schedule, Malaj, the speaker will be removed. Without any other thing, Malaj. The speaker a motion will be passed or whatever, the speaker may be removed and another speaker may be installed. But that's another issue. That situation has not arisen. At the moment, we are on what? From what date does the disqualification of the speaker commence?
Important question, Anand.
That's all. Now, let me now read something about the Constitution itself.
Yes.
For a minute. No,
I think you've now made your submissions on the reference or the lack of reference.
I'm sorry.
The same thing, whether the reference needs to.
Right, now just one other. Yes, one other thing. There's a judgment of the UP Allahabad High Court, 1964 judgment which deals with this issue, luckily.
64.
And I tell your Lordship what the judgment says. Then I give your Lordship judgment.
Yeah.
Whereas there the question arose that a chairman of the Legislative Council was sought to be removed. Now, at the time when the notice was given, he was there presiding. At the time when a motion was moved, he was still presiding. At the time when the leave was sought to be granted, he was presiding. A writ petition was filed that you could not have presided at the time when leave was granted to move the motion. Right? Leave was refused. So, Manas, The question then arose and the court said, look, under the Constitution and the rules of the Assembly, he is not required to vacate his chair when leave is sought. Because the resolution only comes up for consideration when a particular day is fixed for its consideration. Precisely what we've been arguing before your Lordship. That's the judgment. Let's give it to my Lordship.
60 of PDF.
Page number 60 of the PDF. 3A, volume 3A. 3A, additional compilation.
Page 60.
Yeah. No. Yeah, I'll do that.
It's AJ
Faridi.
Faridi versus
I cannot violate the. Yes, if your Lordship has a PDF page 60.
Yes.
Yes.
Now just see, but just the facts. The petition under Article 226 has been filed by Dr. So-and-so, who is a member of the Assembly. The three opposite parties in the petitions are so-and-so. On 11th February, Faridi and 8 other members of the council gave notice of resolution. Following resolution, Raghunath Vinayak, Dhulekar, being unfit for the office of the chairman of the council, should be removed from the office under 143 of the rules of procedure and conduct of business of the council. Under this rule, a resolution for the removal of the chairman can be moved only if the leave of the house is given for the purpose of 20 members, by 20 members of the house, rising in support of the same, when so required by the chairman to do. The question relating to leave was included as item number 3 in the agenda. On 2nd March, Raghunath Vinayak, Dhulekar, the chairman of the council, was occupying the chair. After the first 2 items of the agenda were gone through, he put the question relating to leave for the aforesaid resolution to the House and asked such of the members as were in favor of leave being granted rising to their seats. And on only 18 members rising, he announced that the leave had been refused. Dr. Faridi and others protested against Dhulekar himself occupying the chair when this matter was put to the House and later walked out. But we are not concerned in this petition with what happened after the chairman had announced the decision of the House. Dr. Faridi has prayed in his petition for a writ directing or order in the nature of mandamus against the opposite parties to the effect that the proceedings relating to item 3 in the agenda of 2nd of March be treated as ultra-virus, the Constitution, and not effected, and further ordering the chairman to proceed according to the provisions of Article 183, 185 of the Constitution. 183 is para-material to 179. Without applying Rule 143 aforesaid, on the ground that it was ultra-virus and illegal. So then this matter is discussed. Para 47.
Page 72.
Page 72. Yes. Yes. My lords have for
Yes.
the words used in clause 1 of 185 are while any resolution for the removal of the chairman from his house, the office is under consideration, and the plain meaning of these words, of course, is that the chairman is required to vacate the chair only when the resolution for his removal from his office is itself under consideration. As has been pointed out earlier, Rule 143 of the Rules of Procedure and Conduct of Business requires that before such a resolution may come up for consideration before the House, leave of the House must be obtained, and it is to be granted by at least 20 members rising in their places in its favor. The rule is within the rule-making authority of the Legislative Assembly under 208 of the Constitution, and the Council having itself provided under this rule that leave of the House must be obtained as a condition precedent to the resolution being moved or for consideration, it cannot be said that the resolution itself was before the House when only leave for moving the resolution was being asked for. Next is, some arguments were advanced as to the meaning of the word consideration used in clause 1 of 125 according to Webster's such act of considering, careful thought, attention, etc. Then the dictionary, rather than just leave a few lines. It is, however, not the meaning of the word consideration which is important. When there is some matter before the House, there is bound to be something before it for consideration. If the resolution itself had been moved, that resolution would be before the House for consideration. And if the question regarding the leave of the House for the resolution being moved was put before the House, it was that question which was under consideration. What is important for being noticed in this connection, therefore, is that not whether the House was considering any matter or applying its mind on the consideration of any matter, but the particular matter which could be regarded as being under consideration of the House. As has just been pointed out by us earlier, what was under consideration of the House was not the resolution itself, but the question as to whether the resolution was to be allowed to be moved. So long as the resolution had not the necessary leave, it could not be before the House. Well, that's, I mean, I'm just pointing out that there's a judgment there. Well, there's two last things that I've done. One is, well, let's kindly read now 179 with me. Last thing. One actually. Some words, Mullahs, have been glossed over, which I'd like to invite my Lord's attention to. 181.1. It says, it starts with the expression, at any sitting of the Legislative Assembly. It's very important, those words. While any resolution for removal of the Speaker from his office is under consideration. So, Mullahs, it has to be a sitting in the Legislative Assembly, not outside, while the resolution is under consideration. So it gives you the time, the point in time.
Your point.
Yes.
Yes.
Not at the time when leave is granted, not any time earlier. While it is under consideration, the Speaker, or while any resolution for the removal of Deputy Speaker for his office is under consideration, the Deputy Speaker shall not, though he is present, preside, and the provisions of Clause 2 of Article 180 shall apply in relation to every such. That's the only embargo. So, Mullahs, the Constitution gives you the point in time, Mullahs, that he cannot preside. Now, this relates to him. There is no conflict of interest between him and third members under the 10th schedule. There is no conflict of interest. So you can't apply the principle of conflict of interest to a proceeding under the 10th schedule where he is dealing with third parties. So the whole premise of the argument is untenable.
Got 2 points here.
Yes.
That is, while is one aspect, and other is that this talks only about himself. And
That's all my contention is. You can't make a constitutional assumption, Mother, because the whole argument has been on the premise that there's a constitutional assumption that he'll act mana fide. When Kyoto Holohon, just that paragraph of Kyoto, Mother, I'll give to your lordships, says you can't attribute to the speaker any such mana fide. That's why the provision of the 10th schedule was upheld. And just give your lordship just the page. I marked it on the. Just that paragraph I'll give to you.
You so easily vacillate from reposing such great confidence on the speaker on the one hand. Within a split second, you would again, I'm saying.
I agree.
In a split second, we know how the speakers have worked.
That's true. But so that's precise. That is why.
These two things which go from.
That is why the minority, according to me, was right. Because only you had to only strike down that part which gives speaker the authority. The rest of the 10th schedule would be maintained. The problem is with the speaker. Yes. Now, the paragraph is. Sorry. I've done this, Para 115. Judgment compilation. PDF page 130.
Of what? 130?
Compilation 1. 1.
Sorry, I could not hear.
Judgment compilation 1, page
Quixote made
135
I
PDF.
said auto judge.
a noble judge, a noble chief justice making a noble assumption about.
That's-
Yes.
The whole
That's not how
paragraph
things.
about-
That's not how things have panned out.
Those are
after
different
1992.
times. Those were
But Malad, the point is you, as a constitutional court, cannot on the assumption proceed that he will act mala fide. That's the point. That's why your lordship keep on asking me, what if he does this and what if he does that? That constitutional assumption you can't make. Otherwise, he should not be the authority which adjudicates.
But can we overlook the situations that have been thrown up after 92?
No, I'm not saying overlook it, Mullah. I'm the last one to say overlook it, Mullah. In fact, I'm the one to say he should not have that authority. But I'm saying as the law stands, So just note them, I will not read it. 115, 118 and 119. And 119, it says, accordingly, the contention that vesting of adjudicated functions in the speaker would by itself vitiate the provision of the ground of likelihood of political bias is unsound and is rejected.
Yes.
Anyway, I'm deeply obliged to you.
Thank you. Thank you.
I see the Chowdar behind your lordships. In the event your lordship is not sitting in a constitutional bench in the afternoon, then I can finish in 10-15 minutes.
What do you want to do?
Because this
Then you can conclude.
I thought so, because
Yes. Nice.
Your lordship will pardon me.
Yes, sir.
Yes, deeply obliged. And I'm grateful to your lordships for the time you've given.
Thank you, Mr. Sibal.
just in point form, a few points. Well, let us get back to the discipline, the core issue arising. Refer or not refer? Should it be reference and why reference? That's the query my lord put between. I think my lord the Chief Justice put it. In fact, Justice Shah and Justice Narasimha also put it. Was Namam Rebia the basis of their case? Was it the basis of the order? Was it the basis of the entire litigation? Now, Mr. Jethmalani tried to address the issue directly today morning. And perhaps he's not been rightly advised. His clients have made repeated averments directly to the contrary. Every argument of my learned friend is belied by in writing pleading. My learned friend has showed one letter to your lordships. Just note in sequence, the lord should be astonished how much entirely reliance on Nabam Rebia, which is why your lordship will refer it, unless your lordship wholesale agrees with Nabam Rebia, obviously. If your lordship doesn't agree with Nabam Rebia, it has to be referred. Now, kindly note that. Just note the pages first to save time, then I'll show the pages. My learned friend, with great respect, has made an oral argument without being advised about his own client's pleadings, or at least his related client's pleadings. PDF 160, I'll give all the PDF first together, so Lordship will be able to follow it more easily. PDF 160, this is all in compilation CC1. That is not case law compilation, but the main CC1.
CC1.
Pleadings.
Convenience compilation.
Yes, CC, convenience compilation. The PDF pages Seriatimar 160, 167, 174 and 193. 4 pages.
193.
Yes. So 160, 167, 170, 193.
174 or
174 you said.
Yes, I'm very sorry.
174 and 193.
That's right. So 160, 167, 174 and 193. And one more thing, Maris. They then have filed written submissions here opposing the reference in your lordship's court. In that written submission, page 3, para 3, there are 5 things. Now, Maris, where is CC1? Now, Maris, remember, your lordship is considering only 2 issues. A, are you agreeing with Namam Rebia or not? That your lordship has already heard in the merits first. These are the errors of Namam Rebia, they are the problems, they are the consequences. The other is, Namam Rebia is only a casual, marginal, possibly inconsequential basis of the other side's case. In which case, even if your lordship disagrees, why should your lordship refer it? Number, this is completely, I'm astonished. Now turn to Bullet 160. My lord has got 160. This is a PDF page. The para I'm referring to is Roman 17. This is how we came on 24th, 25th, 27th, etc. of June.
What is this page 160 that you are reading out?
I am reading 160.
What document?
The actual petition.
Sorry?
Part of the writ petition.
It's the writ petition by which the whole thing was born. Whole thing started, and this is what we argued.
Writ petition filed by them.
On
which 27th order was passed.
On which, and that's the main Shidde petition, if your lordship may so call it. On which everything is founded. That's follows 160, I'm sorry. It's a short paragraph. 34 MLAs of Shiva Sena issued notice, including few independent MLAs, issued notice under Rule 11 of the Maharashtra Assembly, read with Article 179 of the Constitution to the Deputy Speaker, Mr. Zirwal, to move the motion for removal from the office of Deputy Speaker and requested him to refrain from discharging the functions from immediate effect. A true copy of the translated notice of 21 June, etc., for his removal is annexed. Now, there is one important point here. I did not say it until I showed the page. Along with this reliance on Arabia, which I will develop in a minute, is a major suppression. Major suppression. And both suppressio veri and seditio falsi, both aspects also. Your lordship heard hardly 1 hour ago that nothing turns on this because this was rejected. Your lordship heard it just now. Where is the rejection mentioned here? You have come to a court in a vacation seeking urgent interim relief involving the possible toppling of a government. Today, because it suits you, you argue that it was rejected. Now the whole para is here. Lordship will look behind and forward. There is no mention of rejection. It's completely suppressed. Now go on. Kindly proceed further. Now come to 174. So, Malas, there is a remarkable intersection of suppressio veri, seditio falsi, and Malas reliance on Arabia. It will just, when I complete it, you will see the total picture. And Malas, it's true in constitutional adjudication, Malas, we can have very large, nice issues, but ultimately, Malas, there should be some discipline of law. How you came to the court, what you relied on, today your lordship is considering reference, not the merits. 174. Oh, sorry, 167. My apologies. I gave the wrong page.
That specifically refers to Navam Arabia.
Yes. Now comes the ground, the first ground. No, see the whole construct, the basis on which you came, you entered the door with this basis, got an order, and today because Navam doesn't suit you, you have been disloyal to Navam and detaining it. The petitioner is filing the present writ petition on the following amongst other grounds which are taken in the alternative. First ground. First, Deputy Speaker cannot disqualify any member under Schedule 10 during the pendency of his own removal resolution because this Honorable Court in Navam, so-and-so, 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 has held that the Speaker or the Deputy Speaker during the time of the pendency of a notice of resolution for removal cannot disqualify any member. The relevant paragraph reads as follows. Now, we have harassed your lordships enough time in this paragraph, but look at the length of the quotation. This is the writ petition's first ground. This ends at 173 after 3 pages, entirely the same paras we have read. Above. Paras are the same. But no disclosure of rejection. The title is when a resolution for removal of his own removal is pending. Mark the word pending. The next sentence should be, oh, but yesterday it was rejected. Your lordship should know that. The word pending is used, own removal is used. This is a suppression of the worst kind. Now, it's not just, I remember, I'll give you a citation. There is 1976 judgment of the Lordships. Take out that. Which cites 64, just a digression for a minute. Lordship will see what standards the Lordship is to maintain. And it's all right, your Lordship is crowded today, so your Lordships always can't maintain it. 76 Supreme Court cites 64. In 64, Mr. Settleward appeared. I'll give those two citations to your Lordships. And it was found that one of the grounds in the SLP was false or wrong. Misstatement. So Mr. Settleward appeared second time, and the judges agreed with him when he said, I never argued this ground. It is a misstatement. I never argued the ground. And he says, we will take your statement, Mr. Settleward, as correct. We did not grant leave on the basis of this because you never argued this ground. But we will revoke leave. Because there is a misstatement. Now, this misstatement is the basis of getting whatever order you got on 27th.
On 27, according to them, there was no injunction.
No, kindly see, on 25th or 26th or 27th, would the speaker have disqualified or upheld and said no disqualified? Just kindly go step by. This is very important. This is the biggest fiction being propounded to your Lordships. Suppose there was no order by the vacation bench of this court. Just for a minute, efface the slate clean. The speaker would be at liberty on that day, which is the 27th, to either disqualify XYZ or not disqualify. The speaker had given them time till 25th, so his hands are free till 27, 2 days. Your Lordship does it frequently, and I appeared for 2 hours, matter went until 9 o'clock in the night. The learned judge said that the effect is the same, we extend the time, and we'll be hearing the matter. When your Lordship extends the time to file a reply, can the speaker decide? Stays or interim intervention by a Lordship has many forms and models. They come in myriad colors. It's completely a stay. I am repeating, I was there for 3 hours and 2 days. Only Nabam was argued. Only Nabam was read. Now you can today say anything, and possibly, there are video recordings of the hearing. It was argued in the evening, till 9 o'clock. The learned judge sat from 5 o'clock. I mean, we can disagree on Nabam, but we should not say that Nabam is not the basis of your case. This is highly troubling. This is wrong. This is not the tradition of this court. Now, your Lordship has extended the stay for filing, the time for filing reply, the only effect of which is the learned speaker's hands are tied. He can't do anything. And then the judge says, the learned order says, in the interim, and then he says, I'm hearing it on Monday. This was a Thursday or a Friday. Next Monday, I'm hearing it. This will take care of it. But kindly go further. Kindly go further. Now, your Lordship has seen 170, Now come to 174. D. So, your Lordship is having whatever your Lordship makes of this cocktail of suppression, of misstatement, and of Nabam. Whatever your Lordship will see in the overall picture. D for Delhi. That was suppressio vera. This is suggestio falsa. This is a direct affirmative suggestio falsa. Because of the disqualification proceedings initiated against the petitioner is invalid and against the various provisions of the Constitution, as the resolution for removal of Deputy Speaker is already pending for decision, and the disqualification of the petitioner is liable to be set aside solely on this ground. Just because this is Supreme Court. Just because it suits you, you can't say today that it did not have any role, rejected. Over. Finished. That's not your case. Then 193. 190. And I hate to say what the bench would have said or held had this been told to the bench. That's not for me to speculate, and possibly not for Lordships to speculate. 193. Now see the prayer. Nabam was not the basis of our case. Nabam was hardly argued or touched upon. Nabam was one out of many. Now see the prayer. The first prayer again, like that first ground. issue a writ of prohibition, mandamus or any other appropriate writ, direction or order directing R1 to not take any action on the disqualification petition under Rule 6, seeking disqualification of the petitioners under so-and-so, pending before the Honorable Speaker state and not to take any action on the same, mark the 2 lines, until the resolution for removal of Deputy Speaker is decided. Again, of course, that it is, well, now see that written submission, Malas, which is filed now. Now meaning now, Malas, to oppose the reference to Navabrevia. Can you show me that? That is called written submission on behalf of R4, opposing the reference to a bench of 7 honorable judges. Possibly filed before 10 January, I told.
There are 2. One.
Yeah, it's there.
Serial number?
Serial number D.
Indeed.
After both the parties.
What is serial number?
There are 2, Mr. Dr. Singhvi. There are
Serial number is called D answer.
one supplementary and another is original.
First one.
In the first one.
Okay.
It's
Then
called
D.
D. That's right.
E. D1.
Para 3. After hearing, may I read one?
Which one?
3, para 3 in this written submission, which is under
Yes.
D. Page 3, para 3. After hearing both the parties at length on various arguments, including but not limited to the judgment of this Honorable Court, of course, other things must have been said, but the point you thought fit to mention was only Navabrevia here. That's your prime point. That's your showpiece. Including but not limited to the judgment of this Honorable Court in Navam, the division bench of this court as an interim measure extended the time to file the reply to the summons notice of disqualification solely in compliance with the basic principles. This, Wallace, is the stay also. This is the stay. You moment, Wallace, your lordship knows, direct or indirect by any means, your lordship disables the speaker from passing an order X or Y on disqualification. That is a temporary stay. And nobody will question the Supreme Court. Nobody will go ahead after your lordship says, I extend the stay. The court says, no, there was no formal stay. Therefore, I will go and decide the disqualification. Without Wallace,
Yes.
I will time. That cannot happen. Your lordship knows that. So that, Wallace, is my first point. On reference, it is of direct relevance. The Honorable Chief Justice put that question squarely, that please do only tell us about reference. Absent an agreement with all forms, all facets of Navam, your lordship would and must with great respect refer it. Distinguishing it, your lordship has heard enough arguments, is not the correct course of action, is not going to really, it might generate more future litigation than solve any problem. Your lordship would either, in a binary sense, agree or refer. And agreement, according to our side, is not possible for the variety of reasons given respectfully to your lordships. Now, the second aspect is, your lordship has been taken a lot into this 7-day, 14-day notice of intention, actual removal. That's a valid point. But it should not be thought that the reference, as and when it is decided, if made by our lordships, is on a singular point of working out these days or the stage. The reference would raise significant issues, and one of the...
Have you formulated the issues with Dr. Singhvi?
Well, it's not in this writing form. I'll give a one page.
Try that.
Give a one page.
You can try it right now. Because
Yes,
yes. Now.
There are many issues, but the core issue would be. No, I'm just saying, in the light of the argument that 7 days or 14 days can be harmonized. Your lordships can hold on notice of intention to remove or the sitting. No, Manas. Your lordship would have to decide the larger core issue, which a 7-judge bench deserves to decide.
It's not just
whether your lordships can directly or indirectly conflate chapter 3 and 10 schedule. Or to be more precise, 179 to 182, etc. and the 10 schedule. What is the chapter? Chapter 3. Check. It's chapter 3. Yes. We are not saying this is the only issue. Don't misunderstand me. I am on the Navabrevia point. There are many other issues. Tomorrow it will be said that I am giving up all other issues. No. On Navabrevia, the issue is not about days and time and sitting. Now, why It has already been said, so I'll not repeat this, but just note in bullets why this conflation is very dangerous, or at least has to be decided. The heart of the error of Naban is a conflation, a mix-up of two distinct. One, I'm giving Ashwin in bullets the reason. One, not only Kyoto, but starting from Kyoto, case after case after case, constitution bench after constitution bench said, 10th schedule is a code in itself. This has been forgotten. CODE is repeated everywhere. Code in itself. Self-contained autonomous code. This word is very important, Malaz. So, Malaz, it's an impregnable, self-contained code. I made the point indirectly about notwithstand and subject to. But it's a code. That's Kyoto starts with Kyoto, it says it's a self-contained code. So, Malaz, there can't be a conflation like this. Two, there is a continuity envisaged in 10th schedule, even if a lot of adventurous action is happening in the rest of the constitution. Pay the speaker. The para 6.1 which Mr. Sibal read, the proviso, illustrates two things. There cannot be a hiatus, stoppage or lack of continuity in 10th schedule. Malas, they have gone that far to anticipate that he's the speaker. This speaker, Malas, will have a disqualification against himself because he has done some untoward act. And your Lordship has used another phrase, persona designata. Normally, Malas, in 10th schedule, the persona designata is the speaker, and a persona designata means no one else by exclusion. That's the meaning of a persona designata. They anticipated and said, yes, it is a persona designata. But what in the strange case where I myself am facing a disqualification? No stoppage, no lack of continuity, no hiatus. Anybody else will be elected and will become the speaker, so-called, for the 10th schedule purposes. That's proviso to para 6 bracket 1 of the 10th schedule. The third reason you can't conflate, because of the whole idea is continuity. The third reason is that, it was said, Mr. Sibal did say, but I want to elaborate on that there is no 10th schedule of the old kind, now only defenses. Now, your Lordship may not have looked this time, but earlier Lordship saw. 4, 5 and 6 are very interesting clauses. The defenses are very limited now. 4, 5 and 6 are the only defenses. As my Lord knows, there was 3, which is conspicuous by its absence by the 91st Constitution Amendment of 1104 that deleted clause 3, the split. Now just see the nature of the defense, fellows. 1, merger. I'll not read it. That's clause 4. Now, merger, fortunately for all of us, is not even alleged or pleaded or claimed by them. Forget your Lordship finding merger. It is not their case. Second exemption is, a kind of a sympathy, condonation. If he rejoins, there are cases where the person will rejoin. So you have a provision by which he can be let off. That is fine. And 6. Actually, it's only 4 and 5. Sorry.
Only 4 and 5.
3 was there earlier. Sorry. Now, that brings me to the 4th bullet under this. What is the purpose of this? Your Lordship will read Mr. Ashok Sen's speech when 85, this was brought in for the first time, 10th schedule. But he said all this constitutional sin, stigma, purity, all that is there in that speech.
Ayaram.
That had happened, Malaz. There were 2 actual names of actual MLAs in Haryana in 1967. These are the names of actual 2 MLAs. That's how this phrase has occurred. Now, he cites all that. Then your Lordship has these amendments to delete. The object is that defection is a per se doctrine. Defection becomes a per se doctrine because you give highest weight to maintain purity. Well, as your Lordship is, with great respect, thinking of a very, very unique, extreme case. It will be academic, it won't happen in politics. of everybody leaving except the Chief Minister and the Speaker. Theoretically, it can happen. But well before that, everybody will leave, including the Speaker, or he'll be removed, as Sibal said. So it doesn't really arise. It will not, should not come into your Lordship's analysis of how to deal with this Nabam issue. The object is that as long as even the majority or large number or small number, minority, split, anything goes, we bring it straight, because we have found from 85 till these amendments came that the split and so many other defenses were being used. So, therefore, it's a per se doctrine. In a per se doctrine is the fifth bullet. The Speaker has to get only two things, Kindly note that. What does he have to get? Why? He has to get, any evidence of voluntarily giving up or voting or abstaining. They're the only two categories. Now, second is easy. There's a whip to be shown. You absented yourself or did not vote. The first one is, your Lordship is interpreted in 10 judgments by conduct, by going to the governor, by being photographed on a podium with giving speeches with the opposition. All the judgments are there. So the Speaker must act if the 10th schedule is a constitutional sin prevention. Your Lordship cannot allow the other side to ask him, you can act, but you may be biased. May be biased. So that's my second point. My third point is, this alacrity point. And I'm not on the general point which your Lordships asked, but on the particular point which both Chief Justice and Justice Narasimha asked, on the notice period. Your Lordship said they may have some relevance to what is the notice period which the Speaker gives. Now, there, just for the record, your Lordship asked that question. Just note down this and then I'll give your Lordship. There are three judgments which are very important. Lordship, note down, then I'll give your Lordship. One is Ravi Nayak. It's a division bench from Goa. 1994 Supplementary to SCC 641. PDF 191 of the CC1 case law compilation.
Supplementary to SCC page?
94 Supplementary to SCC 641. It starts as your Lordship's compilation of cases as PDF 191. And the relevant part is para 24 at PDF 204. Don't go to it, just give me a minute. Don't go to it now. The second judgment is Yedurappa, which is not in any compilation that I know of. Just note the citation, need not go to it. 2011, 7 SCC, page 1. Both of these, Ravi Nayak and Yedurappa, are division benches. Both are division benches. The judgment I'll take your Lordships to, which covers these two, is Srimant Patil, which is 2020, volume 2 SCC 595, PDF starting page 1249, and relevant paras are 109 to 112. The ratio is in 112, and the PDF page is 1292. Now, note, two things before I read that last judgment only. Goa, which is Ravi Nayak, has a rule of 7 days. Goa has 7 days. Both the Karnataka judgments, Yedurappa and Srimant Patil, also have 7 days. So, Karnataka rule is the same as Goa. The actual notice in Ravi Nayak was 2 days. So, less than the rule prescribed. This has great relevance to both the Honorable Chief Justice's query and Justice Narasimha's recollection on that, which is important. In Yedurappa, 3 days was given, and Srimant Patil, 3 days was given. Again, the rule said 7 days. The nub of the matter is that in Srimant Patil, the 3-judge bench said that what is important is not just the text of the 7-day rule in the legislative rules. The legislative rule will not be mandatory and will not be dispositive. What matters is that because of the urgency and the constitutional sin involved, did he get an effective chance or not? If he gets an effective chance in 3 days or 2 days, it is enough. It's reasonable opportunity. This also sets a record straight because it is not as if Yedurappa is ruling. It has been distinguished and in fact, in that sense, not followed by a three-judge bench. Kindly see this in the judgments compilation. Just the last one will suffice. Please. At page
129 is only about whether under disqualified inadequate notice.
Compilation 1.
Case law compilation 1, 1292.
Internal proceedings of the House which you are being
129.
is now its disqualification maintained the Supreme of the House of the Speaker.
This is all based on alacrity.
Sriman,
2 days, 3 days, urgency. Of course, even 10 days may not be effective. I'm traveling in Iceland and I get 8 days notice. I may not be able to. And I'm right there, I know everything is happening, then 2 days is enough also. So 109 it starts. The relevant is only 112, but let me just read 109. May I read?
Yes.
At page 1292. My lords have got it?
Yes.
The petitioners contend that the principles of natural justice were breached when the Speaker provided for a 3-day notice in derogation of 7(3)(b) of the Karnataka so-and-so rules, wherein a 7-day period is prescribed. On the contrary, the respondents have emphatically stressed on the fact that there was adequate opportunity given to the disqualified members to make out their case before the Speaker. So look at the rival contentions. Counting the days in a sterile manner and the actual effectiveness of the opportunity or adequate opportunity given. That was the rival contention. Principle of natural justice cannot be reduced to the straitjacket formula. The yardstick of judging the compliance of natural justice depends on the facts of each case. In Das, it is well established, then they quote Das first. This court in Kyoto held that Speaker decides the question as to disqualification adjudicatory disposition. This view received further elaboration by this court in Ravi Nayak. An order of an authority exercising judicial or quasi-judicial functions passed in violation of principle of natural justice is procedurally ultra vires, therefore suffers from a jurisdictional error. That is the reason why, in spite of the finality imparted to the decision of the Speaker Chairman by 6-1, such decision is subject to judicial review on the ground of non-compliance with the rule of natural justice. But while applying the principle of natural justice must be borne in mind, they are not immutable but flexible. They are not cast in a rigid mold, cannot be put in a legal straitjacket. Whether requirements of natural justice have been complied with or not has to be considered in the context of the facts and circumstances. At this point, the petitioners have placed reliance on Yedurappa. This was the rival view, and argued that in that case, this court had struck down the disqualification order solely on the basis of the fact that only 3 days' notice was given to the members. Now the 3-judge bench leans in favor of Ravi Nayak. However, it is relevant to point out that Ravi Nayak's case, a disqualification order wherein the Speaker had granted 2 days' notice to the members, was upheld. The question is therefore not the number of days that were given by the Speaker for answering the show cause, rather to see whether an effective opportunity of hearing was provided. This brings us to the point already reiterated and not a straitjacket formula. So, this is the overwhelming alacrity fed into all judgments of 10th schedule because of the overall object. And one last thing here about alacrity. There is a judgment of your Lordship from Maharashtra, I believe. Jalmi versus Speaker. 1993 to SCC 703. Give me the PDF page. PDF page.
168.
Same compilation, PDF 168.
93?
1993 to SCC 703. Para is 20. The starting page of the PDF is 168. Para 20 is at PDF page
179.
179. Open it. There is no indication in Vrindavan Nayak 65 that the delay in raising the question of disqualification provides justification for refusing to decide the same. And the emphasis really is on a prompt decision by the competent authority on the question being raised, since it is not in the interest of the constituency which such a member represents to delay the decision. It's the other way around. One of my friends argued that the constituency will become vacant. On the other way around, the cloud should be decided this way or that way. This decision is an indication the authority competent to decide must act promptly in deciding the same. Once it is raised even by a citizen, in order to prevent a disqualified member from representing the constituency after incurring disqualification subsequent to his election, so long the question remains a live issue during the tenure of the member.
This is dealt with. This is on general promptness. I'm not on the case today. It's on general promptness. Now, Malas, two more things and I'm done. One is, Malas, I believe Mr. Marinder Singh read Shivraj Chauhan or Mr. Jethalani. That I'm not getting into, Malas. There are two delightful paras there which are directly in my favor. Shivraj Chauhan, which I had the privilege of arguing before a bench of which my Lord the Chief Justice was a member, was a reverse case on facts. But your Lordship accepts today's principle in the very para my learned friend has read. Can you turn to that for a minute? PDF 1390, para 80. The principle your Lordship accepts, but the converse set of facts, it applies in the reverse. Judges have given up their lunch, you can wait until later. Now, Manas.
We are not saying anything, yeah?
Well, I am replying to Mr. Maninder Singh, Manas. If your Lordship is gracious enough to give up your lunch, Manas, we can all wait for 5-7 minutes more, Manas. Don't keep on doing. Manas, para 80 is what my learned friend read. I'll read only my two portions selectively, Manas. Placitum B to C and placitum E to F. Can you note that in the same para 80?
Yes.
And kindly underline those lines. When you focus on the line, it becomes clear, Manas, what is the... This is on the non-conflation, the core point that you must keep them apart. Code versus a separate part of the Constitution. I'm reading from B, placitum. The holding of a trust vote operates in a distinct field from the issue as to whether one or more individual members of the Assembly have embarked upon a voluntary act of resignation or have incurred the wrath of the 10th schedule. Holding a trust vote is necessary to ascertain whether the Council of Ministers, headed by the Chief Minister, has the confidence of the House. Then Your Lordship goes on, the continuous existence of that confidence is crucial. So that is one category, Your Lordship says. Now see below, E. E placitum, 2 lines below E. Neither the governor nor for that matter the court can entrench upon the power of the speaker. But the pendency of the proceedings before the speaker cannot be a valid basis to not have the confidence of the House in the government determined by convening of a floor test. I'm not saying Your Lordship is dealing with this context, but Your Lordship schematically and conceptually separates the two categories. One is the floor of the House, the other is the 10th schedule.
Neither the governor nor...
And just to end in a minute, that word sitting goes along with the word while. While was mentioned by him, sitting I had mentioned in my opening. 181 uses the crucial word sitting. Now, whereas in Parliament or in assemblies, sitting is on that day, that moment. It's not session. It's not intercession. That's a separate word used. Or days when there are no sittings, which are intercession days. Sitting means an actual sitting of the House. So notified. When the attendance registers are open for the members to get their daily allowance of 1,500 rupees. Therefore, that sitting word with while read together makes it crystal clear that the speaker is activated or disabled for that sitting when that removal will have relevance. While that removal in that sitting. Well, can I give you Lordships this one issue I have formulated, the core issue of conflating or not conflating. If your Lordship would want, I can give a one-pager on the issues by today evening.
Certainly, you can give us one
But just take
pager.
note of this and answer this also. There's a little contra judgment which has taken a different view. 2012 2 SCC 708.
Just get it from here.
Could I just on facts?
No, Your Lordship, I have another question.
That 21st issue of the letter not being pointed out. Since I was there, could I just indicate, because that came in the rejoinder, just that and Nike, I'll take 2 minutes, if your Lordship permit. Well, as far as Nike, which is now being cited in rejoinder,
708.
my learned friend is wrong, because Nike was a case where the MLAs went and met the governor.
Okay.
There were 4 videos taken. And after that, the court said that there are videos of you meeting the governor and withdrawing support, where is the question of more than 2 days notice. We are not talking about withdrawing support. We are talking about that you're no longer the leader within the party.
Anyway,
There's a faction which is in a majority within the
Two things.
party.
Let me
So
deal-
there's no
Let me
defection.
the judge.
Secondly, my lords, on suppression, with great respect, my lords, my learned friend is not being right at all. 21st, firstly, no one said it in the opening, but let me point it out as an officer of the court. 21st of June, a notice is issued on page 49. On 22nd of June, a hard copy of the same notice is received, signed by 34 MLAs. My learned friend refers to an email of 24th of June, which is replied to by saying that this is from a unverified account and we are rejecting. And that very email reply of the speaker says, I've met Mr. Chaudhary, I've met Mr. Prabhu, and I'm satisfied with what they are doing. And my learned friend comes and says that we've suppressed. Dr. Dhawan, on behalf of the deputy speaker, was present in court. He pointed this out or attempted to bring this to the notice of the court to say that we have rejected it. And there the court said, Mr. Dhawan, 34 MLAs have signed it. And you are saying
Let me end.
my learned friend talks about suppression.
That's all.
Let me now end, Malas.
Yes.
By one para of Jagjit Singh and one answer to my Lord's query.
No, just have a look at it.
No, I must answer it. It'll take 2 minutes only because your Lordship is rising. I don't want to take your Lordship. Jagjit Singh case is very important. Just note it, Malas, in your Lordship, same compilation at PDF. 1 second. At 866, actually 865 bottom and onto 866.
Jagjit Singh.
On the same compilation is Jagjit Singh. It's a constitution bench. No, sorry, 3 judges. 3 judges. Constitution bench. 1 minute. Jagjit Singh? दूसरा केस है लिखा हुआ है बोला हुआ Rajendra Singh Rana. No, my apologies. It's called Rajendra Singh Rana. That's a constitution bench. Rajendra Singh Rana, not Jagjit Singh. Rajendra Singh Rana. This para, I just read, Malas. The Lordship will turn to this 866. On the alacrity point which I was on. Just 2 minutes, I'll just finish.
No, we get the point. I mean, that's, have a look,
No,
because for completion, I have given you,
Yes.
not for you.
No, but
What is the
on
page
this
of Rajendra
point,
Singh Rana?
before I answer-
What is the page?
Page 866, continuation of para 45.
Yesterday issued citing.
Yeah, it was cited, yes.
Correct. Now, this part was not read perhaps. Just see
Para,
7 lines above para 46.
para 45.
In para 45, 7 lines above para 46. At page 866.
Yes.
Considering that if the 13 members are found to be disqualified, their continuance in the assembly, even for a day, would be illegal and unconstitutional, and their office as ministers would also be illegal, at least after the expiry of 6 months from the date of their taking charge. We think as a court is bound to protect the constitution and its values and the principle of democracy, basic feature, this court has to take a decision one way or the other on the question of disqualification.
Right,
of the 13.
Thank you.
And Malas, the judgment my lord just handed, that's Yedurappa. That's Yedurappa. And Yedurappa is Malas, my learned friend.
Even as, even assuming,
That your lordship argued that.
even assuming it says.
Yeah. Okay. And Malas, your lordship said contention with para 53.
Not my contention.
No, I'm saying it is directly. Also,
It's
fortunately.
okay, it's a 2 G. That's right. That's a saving grace for you.
We are very, very grateful.
But by very deeply
We'll dictate a small order. We have heard Mr. Kapil Sibal and Dr. Abhishek Manu Singhvi and Mr. Learned Senior Counsel, Mr. Devdutt Patnaik on one side, and Mr. Neeraj Kishan Paul, Mr. Mahesh Jetnani. The Solicitor General का नाम पहले तो Mr. Neeraj Kishan Paul, Mr. Mahesh Jetnani, and Mr. Maninder Singh and Mr. Siddharth Bhatnagar, Learned Senior Counsel for the other side. Stop. Arguments have been addressed before this court only on the question as to whether the decision in Nabam Rebia, pura citation le lo, requires to be considered by a larger bench. Full stop. Arguments are concluded on the above aspect. Orders reserved.
Very grateful.
We are very grateful.
Lots about 502.
Mr. Attorney? Yes.
The next matter, 502. Would lot like to cover this next week. Next week there are some fixed bench matters and
You have some other, all right, then I think we'll not immediately start with that.
Yeah, my lord, my lord, we can consider having it, my lord, post this holy vacation, my lord.
next
Consider.
there are a couple of.
We'll just consider, yeah.
Very well.
Please,
Sorry,
sir.
but
Not this afternoon.
Very well.
502 has your lordship taken
10 to 502 will not take today.
today.
So, yes, we'll see when to list it. We'll give you enough, we'll give you enough.
Kindly give notice also.
Yes.
503. That other NCT matters. So
yes.
will give us an
The
indication.
writ petition.
The writ petition on the amendment of the statute.
On the amendment.
That's before the
Statute amendment.
regular bench, not before a constitution bench.
Of course, it is.
Well, the understanding was.
Yes, of course
Take
it
up
is
this matter after this matter, so could it be on?
We are going to take it up after this matter, but not this afternoon, that's all.
Very well. Very well.
I did it.